Welcome to Law Talk Today, a series devoted to bringing you informative and educational programs focused on issues of law, government, and community. Hello, and welcome to LawTalkToday.tv. I'm Dan Agatino, your host. Joining us in studio today is Rosa Rickett, an attorney who practices in education law. Rosa, thanks so much for coming in.
Hello, Dan. Thanks for having me back.
So this is our second visit together, and I thought this time we could go into greater detail about the process of what happens when a parent suspects their child needs some special education.
Yes, that is a very important question, Dan, for us to discuss. It's important for members of the community to know what would happen in that type of a situation. Normally, when a child is suspected of having a disability, it could happen either way, that they will actually be referred for an evaluative process. They can be referred by their teacher or a parent, or they can be referred by an administrative member that sees them on a regular basis. If it is a parent that's making the referral to the child study team in the child's school district for an evaluation in order...
Let's stop right there.
Okay.
Child study team, so just so the audience knows
what it is. Okay.
Yeah.
Every school district has a child study team within the school district. They are a group of professionals. They usually consist of speech therapists, school psychologists, occupational therapists, various professionals that provide services to children that have special needs. Those members of the team would be the ones to evaluate any child that they believe is referred to them as having a disability. But the child study team has to have a reasonable basis based on which they believe the child has to be evaluated. In other words, just because a child is referred to them by a parent, if a parent puts it in writing and says, dear school district, please evaluate my child. I believe that my child is not progressing academically due to the fact that they may have some type of a disability. I'd like for them to be evaluated, and I'd like for it to be determined whether or not they're eligible to receive special education and related services in order to receive a free appropriate education. If the school district, meaning the child study team, that will take a look at the request and determine that that's not a reasonable basis, or they have not observed something, or they don't have teachers or other members of the school staff telling them that, you know, yeah, there might be something going on, we should take a look at this student. If there is no reasonable basis, they can actually reject the referral from the parents and say, no, we don't believe that there's a reasonable basis based on which the child should be evaluated. So
they have some discretion. It's not just the will of the parents.
Yes. However, the parents do have a right to bring them to a due process through the administrative courts in order to show, you know, basically litigate with them as to whether or not the child should be evaluated.
So let's go through that, because for those who don't understand what due process is, and it simply means if I'm a parent, I believe my child needs to be evaluated. I write to the child study team, let them know I have an interest in having my child evaluated. Child study team says, nope, we're not doing it. Then I have a right to go to court and make them do it.
Then you have the right to go to court, and the judge will decide based on the data presented from both sides as to whether or not there is a reasonable basis based on which the child should be evaluated.
Okay.
And there are times, of course, when the court will look at the data presented and say, it's reasonable for this child to be evaluated. Because if a child is evaluated, it's not necessarily that at the end of that process they will be classified as eligible to receive special education related services. It just simply means that they will actually have a battery of tests administered to them. They will be observed by the professionals on the child study team, and at the end there will be a meeting, an eligibility meeting, eligibility determination meeting, where the evaluative reports will be discussed with the parents, and it will be determined. The child study team will present their position and say, yes, we believe, based on the data we've collected and then on the tests that we've administered to your child, that they should receive specialized education and related services, or no, we will not. And then, of course, at that point, the parents again have the right to take the school district to the through the due process or litigate the matter in the event that they are at the end of the evaluative process rejected again for specialized education.
So you could go to the courts twice. You could say on the first step, If the child study team says, no, we're not going to evaluate, see if a court will enforce the evaluation,
Sure.
say that you must do it. Then after the evaluation, if the child study team says, no, there's no problem, and you still believe there's a problem, you go to the courts and the judge can say, there's a problem.
Right. But you, I mean, you meaning a parent, at that point, my recommendation would be, of course, to either, hire a parent-child advocate who is well-versed in this area, or an attorney that can take a look at the data, and of course, give a parent an advice as to whether or not they really have a leg to stand on in court. Because I don't want to recommend for parents to start running into the court to enforce for school districts to do these things unless there really is a reason based on which the child should receive specialized education.
What is a parent-child advocate?
A parent-child advocate is an alternative to an attorney, such as myself, that practices in the area of education law, who is somebody that is also trained in working with parents and school districts in trying to get kids evaluated or trying to get kids an appropriate educational program once they have been determined as eligible, who can assist parents on a much more reduced rate, of course, of an hourly billable rate where they will be cheaper than an attorney. But that can take the parents through the process of dealing with the school districts and kind of mediating between the parent and the school district an appropriate program for the student. They're very effective. There's a lot of excellent parent-child advocates in the state. The only downfall of a parent-child advocate is that if a parent has to go to litigation, meaning to court with this issue, most of the time, even if a parent-child advocate can file a complaint for them, can go to mediation with them once it is in administrative courts, beyond that point, a parent-child advocate really can't handle the case as an attorney who is trained on how to, conduct a trial, present witnesses, et cetera, would. So at that, with respect to that position, it's difficult for parent-child advocates to carry the case through. And at that point, if a parent finds themselves in that position where they have to litigate it in court, they are then forced to hire attorneys who then have to catch up from the beginning as to what has happened and, handle the case.
So let's take a hypothetical. We won't go into court. We'll just say that we've gone through the study and the child needs some strong help, we'll say.
Okay.
What's the law? So if my child has Asperger's, has Down syndrome, has special needs, there's a whole spectrum that we could go over. Maybe they're autistic, maybe fill in the blank.
Sure.
Can the school board say, we're sorry that this has happened to your child, but it would cost us too much money in order to educate your child, so please leave us alone?
Absolutely not.
Not?
No. If
No.
you have a child that, for example, is autistic or falls into one of the categories based on which a child can be found as eligible to receive special education-related services under the Individuals with Disabilities Education Act, the school district has to educate that child, no matter how much it costs.
Let's stop and say that again, in case somebody wants to go online to look it up. The IDEA stands for?
Individuals with Disabilities Education Act.
That's a state act or a federal act?
Oh, it's a federal law.
Okay.
And based on that law, any child that has any sort of a disability that affects their ability to learn has a right to be educated for free, to receive a free public education, also known as FAPE, short for free public education. They have a right to be educated by the school district in which they are enrolled.
Okay. So they have free access to a public education.
Absolutely.
And they have the same rights as someone who does not have a learning disability.
They absolutely do. And so the way that would happen is, for an example, let's take your listeners and your viewers through the exact process of that,
Please.
how that would happen.